Good afternoon. Thank you. As you can tell, we're done with lunch, and we're running a little bit ahead of time, which I'm very happy with, because it means we get more time with our guests. You know who's on the panel, Senator Weinberg and John Paff, and we're going to discuss in a little bit more detail the proposed amendments to the Open Public Records Act and the Open Public Meetings Act. And Senator, I'd like to direct the first question to you, and I understand you may not be able to get into this, but can you discuss some of the compromises that have been reached among the stakeholders, especially regarding the Open Public Meetings Act amendment?
Well, probably not specifically, because actually I just got them in the last few days, and you have the ACLU here who probably can be a little bit more specific about it than I can. But let me just say what we obviously had to update both of these laws. One hadn't been touched, I think, in 40 years, and all due respect to Al Gore, the internet was not even a word at the time that the law was first written, and certainly iPads and Blackberries and iPhones and whatever else were not even dreamed about. So there was a necessity to update because of the modern technology, if for no other reason. But the other aspect of it, or one that's important to me in any event, was we want to try to set the environment that everything is open. It's not everything is closed with the exception of those things we have to do in the open. But everything is in the open with the exception of a few carefully crafted exceptions which make sense, which most of you, I think, are familiar with: labor negotiations, attorney-client privilege, those kinds of issues. So it's, first of all, setting the environment. The initial reaction from the league, from mayors, from municipal clerks, is the end of the world is coming, we will not be able to function. And if we move ahead with anything here. And, but I think slowly, with the help of the courts, by the way, who every time they make another decision, it's something we've already covered in the law, with the help of the courts. You know, for instance, emails where a majority of the governing body or the independent agency is engaging in the discussion of public business, that becomes an open record. And the courts have already made some decisions along those lines. That's a classic example of a method of communication that didn't exist. One of the things that has caused a lot of consternation is that we won't allow emailing and texting between and among members of the public body during a public meeting. Because members of the public have come and said that they suspect that Mr. Brown is texting Ms. Smith at the other end of the dais saying, you vote yes and I'll vote no, or let's both vote yes, or whatever. We're not preventing that kind of a discussion, you just have to do it publicly, not via some mechanism. But we made some exceptions, so it's another, I guess, an example of the compromise. I know this is a long answer, but I want to give you the overview. That if a member of the council wants to text one of his or her staffers to ask a routine question, does the bill say whatever, that will be allowed. So we made some accommodations here. You know, we heard oh, well, what if my wife has to get me because there's an emergency at home? Yeah, well, I bet your wife will find a way to contact you if there's an emergency at home. But, I mean, that's the kind of thing. We met with municipal clerks. We are holding clerks harmless in certain areas. It's another compromise, came out of the meeting with clerks, that if they're in a closed meeting and the municipal clerk says to the governing body, this should not be in closed session, and the governing body ignores the municipal clerk, clerk makes a note in the minutes, and then the clerk is held harmless for any action that takes place. So I ensure, who is an old friend, a clerk from, former retired clerk from Bergen County. And one of the other major issues we wrestled with, which we didn't really find a great solution to, but the issue that's raised by municipalities, clerks, elected officials, is the gadfly issue. The person who is making an OPRA request 3 times a day, every day of the week, which can become cumbersome and can be considered frivolous. And we wrestled with that, but there's no way that constitutionally we can limit how many times people can ask for records. Just pretty straightforward, but the more that's online, the less work for the municipality. So we do allow a municipality to go to court on like a frivolous lawsuit, same kind of standards, if they consider they've really been badgered by frivolous complaints. So there's a little bit of that in there. And we compromised, I think, on the length of time to respond to an OPRA request, but not too much thereafter. And I will say that the League, and I said it in my more formal remarks, has really been a willing partner, I think, with the ACLU in trying to work out these differences. So,
do you want to address any of that, John?
No, I'm fine.
Okay. Senator, I'm going to give you the question that I get with increased frequency, which is, when might we expect these bills to go to the floor?
I am hoping by the end of the year, because we're down to the end. I have pushed them through the committee level just so we wouldn't have to start that all over again, each time promising. It's been through state government, second reference to budget, it's been through budget, and each time promising that I was going to work out as best we could the disagreements. So we have it through committee. So, and then we took what became the committee substitute, a lot of the changes that we incorporated, and we sent it out to everybody and anybody who had given us input. And we said to them, okay, here's the closest version I can get to what we might be voting on. Let us know. And we only heard from, I think, 1 or 2 municipalities. Nobody else weighed in. But then we had this meeting with the ACLU and the League. So that's the final step, incorporating those. So I feel confident that at least in the Senate, we will be able to get this version now up and passed. I'm hoping we're going to have bipartisan support, and we're going to count on grassroots groups here to help us with that.
Thank you very much. Senator, one of the ways that the amendment would change the Open Public Meetings Act is that subcommittees would be covered. They have to prepare minutes, they have to give notice of their meetings. And that is, in my view, a rather large change, because we know, and folks have discussed here earlier today, that a lot of business does get done in subcommittee. So I've read some objections that this will, to varying degrees, increase the burden on a municipality, on the clerk, because now they have to create more sets of minutes for all these subcommittees. What's your response to that?
Too bad. You know, I don't mean to be so cavalier, but subcommittees are important. And I don't have to tell this audience that very often the business of government is done there, and then they give them the subcommittee report, and they all say yes, you know, and you don't know what the thought process was. So minutes don't have to be detailed. You can record them if you wish. Then you don't even have to take them. You can record them, keep the video or the audio, and let people see it. So there's lots of ways around it, but we're keeping that in the bill.
John, as you know, the current amendments would create a fee-shifting provision in the Open Public Meetings Act, which in general means that if a person prevails in litigation, the losing party, which in this case would be the municipality, would have to pay the winner's attorney's fees. What do you think about that? Do you think it'll cause an increase in Meetings Act litigation? Do you think it'll cause an increase in compliance? What's your view?
I think that it's a good thing, and I think that that during the first several months, there's going to be almost a panic as to how municipalities are supposed to comply. There will probably be government agencies that really go overboard and do things they don't even have to do because they're not sure where the lines are falling. I'm just sure it's going to be it's going to be disruptive until the courts come down at the appellate level with some clarity on exactly what it is they're supposed to do and when exactly the fees get triggered. But I think that for the first time since 1975 when this act was passed, you're going to see actual enforcement. You're essentially deputizing every attorney in the state of New Jersey to act as an attorney general. You're saying that if any citizen wants to bring in action, and the attorney fee shifting provision, to be specific, is in two parts. One is if you set aside a government action in accordance with 15 of the Act, or two is if you apply to the Superior Court for injunctive relief or other remedies. So I think that what you're going to see is a lot of the turning a willful blind eye toward compliance to OPRA is going to disappear literally overnight. As it stands, I see the boards, they size me up, the public agencies size me up and say, we know you have limited resources, we know that it costs you money and time to do this, we know that as a citizen activist who files pro se lawsuits, that it's not easy for you to file suits in every county of the state. So we are going to take our position and hold to it that we don't really have to put good detail in our resolutions announcing what we're going to talk about in executive session. We don't really have to produce the meeting minutes in comprehensible form in a timely manner, because we know that there aren't enough citizens in the state that actually can take us to task or pay an attorney. There's so many bodies, and they are so non-compliant. What this will do is every one of these bodies now have to say any citizen, that quote-unquote gadfly, not really a word I like, that's been coming to these meetings for years and complaining, can now go out and get an attorney, and they can sue us. And if he gets injunctive relief, he gets his money back. We have to pay that lawyer. I think that it's going to cause a whole lot of self-evaluation by all these bodies, and they're going to start really complying very quickly overnight. I think that's going to be one of the most important aspects of this legislation.
Senator, would you care to weigh in on that aspect of the amendment?
Yeah, well, you already heard John say that he thinks it's a good thing. But it brought to mind another subject, the so-called Government Records Council, because we address that in this bill. We address to have a new Government Records Council, the municipal clerk on it, member of the public on it. I, along with a couple of members of my staff, went unannounced to a Government Records Council meeting just to see how they operate. And you want to talk about being shocked. I mean, this is the body that is charged with making sure that people's rights are protected when they go for open records. And I mean, it was almost worthy of a Saturday Night Live routine. You could not make heads or tails out of what they were doing. The agenda would be something like Paff versus the Township of Teaneck. Can I have a motion? So moved. All those in favor say aye. Well, not only don't you know about the case, but are you who won? Can I have a motion? So moved. And there was a poor guy sitting in the audience from Newark. I think he was from Newark, who had driven 3 times to the Government Records Council. He had some kind of a case pending, and he was just trying to find out what they did with his case, which was voted on in exactly that manner. Can I have a motion? And they said, we'll let you know in writing. So, I mean, I was amazed, and the commissioner of the Department of Community Affairs contacted me very quickly, and he's made some unilateral changes in the way they operate, I hope. But in spite of that, we are trying to put something into the legislation so that people do have a really fair body to go to without going to court, without engaging an attorney, a body that will be made up more fairly and will have to maintain open records themselves. So.
It's very interesting that you say those things, because when I wear my other hat, my litigator's hat, we will use the Government Records Council when the information we want is not important. When we can wait 18 months for the document. If the information we're looking for has any importance or any time sensitivity, we'll go right to Superior Court. And we've already taken sort of the important cases away from the GRC. And that's the first question I ask folks. How quickly do you need this information? Because the GRC is free, it's user-friendly from a filing standpoint, but then you have an 18-month adjudication schedule. And what frustrates some people is we can go to a Superior Court judge and get, a couple of pages of written findings or findings on the record, and that happens in 1 to 3 months if you proceed by an order to show cause. The GRC produces these 20 to 30 page decisions, mostly boilerplate, and it takes a very long time. So it is very frustrating. I don't know if this has been affected by any recent discussion, but the last time I read the draft was that the GRC had to adjudicate a case within 120
Yes.
business days,
Yes.
and that's still
It's 150
present.
calendar, 150 calendar days.
And if you live in Teaneck, those business days are only 4 days a week. Don't laugh. That's really held us off on, so a 7-day OPRA request could take 3 weeks when you start counting business days.
Yes. So is there any support for the notion that, is the issue with the GRC that, is it a management issue or is it a resource issue? If you can say.
We can't say I know the answer to the question, but when I went to the meeting, there were a lot of people sitting there. So, I don't even know who were members and who were staff, but it seemed to me there was a huge group of folks sitting around the head table. And my guess is it just grew up like that, and it goes, again, like so many other things, it just goes along till somebody asks the question. And of course, I could see the startled look on everybody's face when we walked in. They were waiting for me to stand up and say something, and I had nothing to say. I was just kind of sitting there looking. So it was an interesting experience. And I'm hoping we improve that. And my guess is it's not a resource issue, because you can probably boil those 30 pages down to the same 3 that a judge can, and can do it much more quickly and expeditiously, and that you don't have to say to an applicant who has attended his 3rd meeting, we're not going to tell you, even though we just voted on it. You can't tell how they voted by the way the repartee goes, and we're not going to tell you until we issue it in writing. I mean, that seems to me you're creating a lot of work for yourself.
It is fascinating, Senator, especially when I do like, when folks began expressing frustration to me about GRC, I compared it to my experience with Superior Court. And if a Superior Court judge who has a caseload of hundreds, if not thousands, can just deal with issues that are more sophisticated than what I take to the GRC in an oral finding or in a 5 to 10 page decision, they always do it quicker, always.
By the way, I would recommend that you do request a meeting with the commissioner, because I don't know whether we scared him or what, or whether he just had good intentions. I'm willing to believe that. But he was very receptive and made some very quick changes there. Mm-hmm. So I think I think it's worthwhile to bring up some of your more specific questions of why they've created this paperwork bureaucracy.
Thank you, Senator Bouchel. John, I know you've spent a lot of time with the GRC as a litigant. Do you have anything to add to that?
I used to actually attend the GRC meetings almost on a monthly basis. And I wasn't clear as to exactly why I was doing it. And then later, I found that attending GRC meetings was largely a waste of my time. There was nothing to be accomplished. I'm reading and I've read it before, but I'm reading some of the things that this legislation is putting in is things that the GRC used to do. And that's to have paper copies available at the meeting at which the case will be heard with any changes or additions that were not present when the information was posted online. Well, they used to hand out the executive director's recommendations that the council was going to vote upon at the meeting. So you could go to a folder and pick it up and read it and understand what the case was about. And then they decided that those decisions were advisory, consultative, and deliberative because they hadn't yet been ratified or voted on by the body, so they removed them. And then if you asked really nicely, they might give you one if you were particularly interested in it, but I always felt like they really were trying to withhold this. I mean, and they were worried that they were going to violate a right that I think was more illusory than anything else. And the other thing that I just have to comment on is this legislation, you shouldn't need legislation to do this. Excuse me 1 second, is to have the council shall make available on its website a searchable index of its opinions. That is something that, who is that? Okay. I'm making sure it's not me. Okay, sorry. They shouldn't have to have legislation that says that they have to have a searchable index of their own opinions on their own website. If you ever look at the GRC's website and try to search for something, it's ludicrous. They require you to search only on certain fields that they've predefined. And you can't just do a general word search. I mean, it is so deficient and it could be so good. And the fact that the GRC, in and of its own self, couldn't say, wow, we really need to improve our website, the fact that it takes an act of the legislature to get them to use basic search functions on their site, I think that's disappointing. But the GRC, again, like Walter said, we go to them when we want them to slavishly follow what they've done before. And if we don't care if it takes 150 or 180 or 275 days for them to reach an adjudication. And, you know, most people, the whole point of OPRA was to provide ready and prompt access to public records, and that rings rather hollow when you have, when they deny you, and to enforce it, you have to wait nearly 2 years. And for a while on their agenda, they had a place for cases where they couldn't develop a quorum to ever work on them. I mean, there's a lot of systemic issues with the GRC, and I don't know if this legislation is going to solve all of it, but I hope that the GRC just kind of gets back to its roots and determines what its mission is supposed to be and starts to act consistent with what people expect it to do. Because I think I speak for a lot of people that over the years the GRC has become quite a disappointment. It hasn't lived up to what it was intended to do.
Thank you. The next issue I wanted to discuss is agendas for public meetings. Frequently, I'll get calls from people and they'll tell me, it wasn't on the agenda. And I'll say, that part of the law is almost a dead letter. Because if there's something that wasn't on the agenda, it only has to be on the agenda to the extent known. And folks can always say, well, we didn't know for certain that it was going to be discussed that day. And as you know, the agenda requirement is now being given some very strong teeth. My concern with what I most recently read is that I actually had two concerns. The first concern was, well, what if a member of the public wanted to speak about an item that was not on the agenda, and so that would actually prohibit the public agency from responding? I see that's been addressed.
You sounded like all the mayors and councils who called us about that. Yeah.
Right, and you've addressed that because now they can respond to an item raised by a member of the public.
Incidentally, I have to just say that I think some of the mayors and councilmen who raised an objection, this is the first time in their history, professional career, they've ever really cared what the public has to say about anything. Just to some of them. I have to sometimes take some of the objections that I read, and I sort of have to roll my eyes back in my head and kind of get glazed over. They're mainly, it's a red herring. All of a sudden we care. I mean, I'm sorry.
But that was, somebody comes and asks us about a pothole. We're not going to be able to respond and say, okay, we'll fill the pothole next week because it's not on the agenda. So we allow the addition, I think, if it's a 2/3 vote of the governing body.
Yes, and that's what I wanted to ask you about, because I think it's very difficult to give the agenda requirement teeth, because the public doesn't want to be sandbagged, but we can't tie the hands of the public agency to do the business either. My question is, as you know, most of the votes in public agencies are 7-0, 6-0, etc. Are we ending up right where we started, where if the power to amend an agenda rests with a 2/3 vote?
Well, I would hope not, because I think the fact that they actually have to take a vote in public makes the elected official much more responsive. They're not just saying okay, or it's not an aside comment. So it's one of those issues, and I've served on a local council, so I know what it's like in terms of being able to engage the public or respond to the public. So I hope we found a good solution, and if we didn't, we'll revisit it.
John, do you want to weigh in on that?
Yeah, on the agenda question, I think I agree with the senator that I think that if they actually have to vote, like just take a scenario where, I've seen this happen, it's terrible, where you have a group of citizens that they're interested in a specific issue that they're afraid the government body is going to address in their absence, so they start attending every meeting. And the government, they never give a meeting agenda out until the very day of the meeting. Sometimes they hand out the agenda when you walk in the door is the first time you get to look at the agenda. So the person who's organizing this citizen activist group has to keep bringing his troops out or her troops out to each one of these meetings. And I think that sometimes the mayor and the council sit there and they figure out, they wait until after the furor dies down, the fervor dies down, and they just want to, and they wait to see that the diminishing group of people. And that really is exactly the opposite of what democracy is supposed to be. So if they decided, after waiting it out and waiting for everybody to, but see, first off, this would help because the public would be able to see if the matter is listed on the agenda. And if it's not listed on the agenda and the town council knows darn well that it's something of great public interest, I think there's a real political price for that councilman, those council members to pay for saying, oh, we got 2/3 of votes. We see that the people were fooled and they're not showing up to express their displeasure at this action. So let's put this particular item on the agenda and use our 2/3. Like, can I get a motion for that? I think that that even the most ornery, the political savviness, the political self-survival would cause them to not do that. As it currently is, there's no rule. At least they would have to affirmatively vote, yes, we want to keep this, we want to hide the ball from the public, and this is how we're doing it. So I think that this 2/3 thing is a reasonable compromise. Again, we'll have to see how it works out in practice. We'll see what happens. That's all.
We also have in the bill a requirement that the public be notified of a time at each meeting when public input will be taken, which also caused a big furor, but in this case, on the side of TNAC, when we did this in the early 90s, when I was on the council, we published that public input will be taken at 9 o'clock or as close to that as possible. So that, because I had sat at the other side of many council meetings, and at midnight when I couldn't see straight anymore, I would get up and go home, and they still hadn't gotten to the public input part. So in TNAC, it's at 9 o'clock, and sometimes it'll be 10 after 9, or sometimes a 9:15 if they get finished with things more quickly. And it has not impeded the business of the community. I mean, they even found a way to move from a 5 to a 4-day work week without public input. But the fact is, whatever we were doing, we stopped. And even if we were in some closed session and we went out at 9 o'clock for what we call good and welfare, I'm not talking about the public input on resolutions. And it's worked for years. So we do have that in the bill, that the public must be informed at a reasonable hour when public input will be taken, so that members of the public don't have to sit there until the wee hours of the morning because the council is doing it on purpose.
Yes, I see some hands, and I actually did want to, we have some extra time. I did want to open it up to questions. Start with Tom.
Just a couple of quick points on the subject of agendas. Hopefully, with any luck, the recent Supreme Court decision in McGovern v. Rutgers will be somewhat helpful in that regard. Perhaps not as much as we all might like, but certainly the Board of Governors of Rutgers was held to the standard of, to the extent known, basically called out on putting out a agenda notice that was deficient in terms of, they knew, in other words, they knew more than what was in their agenda. So hopefully there will be some benefit derived from that case. The ACLU was amicus in that case. Also, in terms of adding items to the agenda, with any luck, if I can tout, in addition to what the senators already mentioned about the partnership between the ACLU and the League of Municipalities, this is one issue that we address that hopefully will make its way back into the pending legislation for setting a requirement for what is needed in order to add an item to the agenda, and that would include such things, in addition to the 2/3 vote, giving the public an opportunity to speak on whether or not the item will be added, ensuring a requirement that the public interest be served by adding the item, and also I think there was another part about requiring that it not be known, that the item not be known in advance in time to make it into the agenda. So similar to the existing requirements for calling an emergency meeting applied to adding an item to the agenda.
My question basically is, we're singling out the council. Will this OPMA also apply, and especially to the open portion, to planning boards, boards of adjustment, all the others? Because I remember being a member of a planning board, and after I was chairman, sitting there till midnight before we opened up to the public, and the objectors to the application, they were gone. We couldn't hear from them. So, you know, we're singling out the council. As far as agendas go, Senator, when I was a clerk, I used to publish my agenda on Friday for a Tuesday meeting, post it. Now, all good attorneys, municipal, always have that last-minute resolution. And I would also publish and post on the public bulletin board in front of the meeting room an addendum, so that when the public came in, there was the agenda, there was the addendum, and it was also placed on the front table. We worked in those days under the rule of every member of the council can place an item on the agenda. No vote. They were elected by the people. They are entitled, if they come in with something and they want it posted, they can place the item on the agenda. And I see nothing wrong with that, instead of a 2/3 vote. Because in partisan towns, the minority party whether it be a D, an R, or whatever, we'll never get that item put on the agenda that way.
Well, it doesn't stop anybody from adding something to the agenda before the agenda goes out. This is only to protect the public so that they know what is going to be discussed and/or voted upon. So the 2/3 vote is to take action at that meeting. If you were sitting on the council, there's nothing for you to say, at the next meeting, I want you to add whatever. There's nothing in the law. And we do, to answer to your other questions, we cover independent authorities, redevelopment entities, improvement authorities, and other quasi-government agencies. They're all covered, including the League of Municipalities, the school boards, all of these organizations that actually get public money in order to operate.
Yeah, 12A is being amended, which is the part that, what it used to say is that, it used to say that you didn't have to have any public portion of the meeting. And then it was amended to say, and I'm talking about the law, was amended to say that the Board of Education and the town council must have a public portion set aside so any member of the public can address the council on any issue that it chooses to, essentially. Now, what this would do is replace that language with just any public agencies, and not quasi, but public agencies, and that would include your planning boards, your boards of education, and every other thing. That there has to be a set-aside portion of the meeting so that the members of the public that choose to attend can address that body on any issues that they determine, not regulated by the issues that the town or the body allows them to talk about. And I see that the part about the comment period, unfortunately, appears to have been removed. I mean, what it says is that it used to say until the Senate, so what this bill I think is saying right now is that they don't have to tell you in the advance notice when the public will be able to speak. They only have to tell you that if the body traditionally goes into executive session as the first order of business and they stay in for who knows how long, maybe 15 minutes,
Yeah,
maybe
well,
an hour. Is that true?
You're right in the way you're reading that, so I have to double check because that's not our.
So what they're saying is at least that's a benefit because it will require the because this way people show up. They have to show up at the meeting at 7 o'clock in self-defense because they don't know if when they're supposed to show up, when the show is going to start. That they go in, they immediately go into executive session. They might be there for 30 minutes. They might be there for 2 hours. So the public sits around and waits around and wears out. And now, at least with this bill, they'll say the executive session is going to be over with at 8:30, and then people know, okay, now I can show up at 8:30 and not have to waste their time, because that was another abusive thing that some public bodies were doing to their citizens.
Double check that.
Okay.
Yeah.
Thank you. Yes, Michelle.
Can I just ask you to identify the two bills you're talking about so people can write them down?
Got the numbers there?
He's got one. This is the one that is the Open Public Meetings Act bill is in the Senate is number 1451, 1451, and in the Assembly is 2426.
And the OPRA amendment is S 1452, and in the Assembly, I don't know.
I guess I didn't write it down.
Well, there's when you go to the legislature's website, you should be able to find both. But the OPRA amendment is S 1452.
But look at the Senate version, because the Assembly versions will be updated when we finish all the updating. So.
We saw some hands.
I just wanted to give you a little bit of information. I work for the Department of Community Affairs and have for the last 26 years. There are 4 people presently employed in GRC. So if they're backed up now, I can't even imagine, because Constable's not hiring anyone, they're not backfilling any positions, and it almost looks like the DCA is going to be eventually at some point phased out.
Okay. And that's very well. I mean, I think that people have to, I mean, if it's a staffing issue, if it's a resource issue, I mean, it doesn't make much sense for the state government to say how important it is to have ready access to open government records and then staff it with an agency that's woefully understaffed. So, I mean, I take your word for what you're saying. I don't know why. In my comments that it's been a disappointment is just that. It has been. I'm not sure why it's a disappointment. I'm not that it hasn't worked.
I got to tell you that you know, folks come to me for advice whether I'm wearing my FOG hat or my attorney's hat, and it does not take me a long time to evaluate the strength of an OPRA request or the strength of a case. I mean, I can do it in like 5 to 10 minutes. Now, I understand that sometimes the GRC gets, you know, big submissions and things are always more complicated, but it's just taken too long. I mean, if a Superior Court judge who's got to handle, you know, the auto negligence cases and personal injury cases, and, you know, if it's an administrative law, excuse me, if it's the assignment judge, they have a whole boatload of administrative duties. You know, they're getting this stuff done a lot faster, and they have a much bigger caseload of much more complex cases.
And I think there's sort of also creative things that they could do. Like in the Superior Court system, they put all cases on a discovery track based on how complex the case is. And we're talking all manner of cases besides open public records. It seems to me, and I'm not 100% sure, but it seems to me what the GRC does, it's kind of like first in, first out. That they don't look at the cases to determine whether, well, that's an easy one, we could dispose of that on track one, and this is a more complicated one that's going to require an in-camera review of 1,000 documents. What they do is they make that simple clerk won't give us the meeting minutes case wait behind that 1,000-page attorney, and it seems like they could probably use the resources. I venture to say, regardless of the amount of resources they have, I think they might be able to use them more efficiently than what they're currently doing, because some of these cases just simply shouldn't take this long. They shouldn't take 18 months. They're very simple, and they shouldn't take 18 months to resolve, even if there's only one person there.
And there's also another sort of interesting issue is that frequently if the GRC sort of smells a factual dispute, they will then punt it to the Office of Administrative Law. And while those judges are, in my opinion, in my experience, very good at moving cases, still, once you send a case to another agency, that's built-in delay. And I'd like to see, and you know, if we have this meeting, we can talk about this, but I'd like to see the GRC sort of shoulder a little bit more of the burden and refer, less frequently refer cases to the OAL, especially if it's stuff that's manageable. Because even if you have the OAL pushing through these cases, which in my experience they've been putting them through faster and faster, there's still always going to be a delay of a couple of months. And if you have to have a hearing, you know, 1 to 2 day hearing, well, now you're looking at like 6 months to 9 months. So it sort of exacerbates the delay. Was there anything else over here?
Is there any legislation that could be written that requires townships to record all of their public meetings, their council meetings, planning board, et cetera, meetings, and either...
That comes under state mandate, state pay. If we required them to have recording equipment, then the state has to pay for it. So what we said in the legislation is if you have it, you have to use it, but if you don't, we found one quite large town where at taxpayer expense, they videoed all their meetings, but then they edited the videos. So we made that, you know, if the taxpayers are paying for a video, you have to release the whole video. You can't edit it to turn it into a PR piece or something.
Okay. Next.
Hi. I guess I'm not getting all this because I probably don't need a mic. For the video. Oh, for the video. Well, then I should have put makeup on. So what I don't understand as a taxpayer, I'm going to go down, I'm going to, let's say, go to the clerk and say, you know, I want this information and its resources and all that. Why can't it just be put online automatically? I mean, this day and age, you can scan minutes in, it's right there. I don't have to bother the clerk, it's there. You got a great search engine, it's there. I'm not getting this.
Well, I think there's a solution. I'm a libertarian, you might have heard, and I'm looking at a private market solution to this. And there's firms out there that are developing software that allows the clerk to, do all manner of things. Like when the council packet is released, they mark which ones are confidential and not. And a public version of the council packet goes online automatically, and it's text searchable, and you can do anything. And it also puts the video, there's a whole integrated camera system in it. And what it does is, as the video progresses, it takes a copy of the resolution that's currently under consideration and puts it in the right-hand portion of the screen, so that the person who is watching the video can actually pause the video and stop and look at the resolution that's currently being considered by the government agency. And this is 2012, and these are things that are well within the grasp of technology. And it seems like, I mean, I deal with some municipal agencies, I mean, believe it or not, that don't even have fax machines. Now, I guess it's state mandate, state pay, but I mean, we're talking to some extent tape recorders and fax machines here. You think you might be able to, I mean, you seem to have money for every other blessed thing under the sun. You think you might be able to just, to find that in your budget. But what I'm encouraging people to do is, I want to try to do some research into these private entities that do these software packages and find out what townships currently use it, and find out how much it costs, and maybe encourage your own town to go and purchase this particular package, with the idea that it will ultimately make it easier on them, because it'll provide ready access to information, not just for the council, not just for the public, but for the council people themselves. It'll just streamline the entire operation. So unless they just willfully don't want to make their stuff public, which is possible, I run into that, maybe that's one way of attacking this as opposed to legislation.
We also had that discussion, I think, with the League and the ACLU about having a state being able to collect all of this information, having a state webpage where everything will be there for all 560 some odd municipalities.
Just don't let the GRC
handle it. Maybe that might become a cost-effective way. Well,
I'm sorry.
I know. I'll be here 3 years from now talking about, what's wrong with that. But we do say that if you've got a web page, you have to post it. We're not requiring the establishment. We are requiring, if you have it, that's where the information should be.
Mr. Gettler.
Wantage Township, we had one township meeting last 8 minutes. That included the Pledge of Allegiance and me being limited to 4 minutes. We had another 10-minute meeting. The township is run by email. Now, we're aware, I believe it was a Burlington County prosecutor put out an opinion on that. If we OPRA the emails, it's all advisory information, it's redacted. How do we cover this? The towns are being run by email. Nothing is being discussed in public. The vote is 3-0. Thank
John,
you.
do you want to address that?
Yeah, I can try.
Well, I guess we should.
Wantage Township.
Wantage Township in Sussex County.
Yeah, well, under this bill, anything that a effective majority is having a discussion, that's public record. We're trying to make people aware of it. I think it was that county where the prosecutor put it out an advisory. Burlington County. Yeah, okay. That if you are emailing, you are now engaging in the public business, and that must be operable. I just want to, while I'm thinking of it, in the subcommittee issue. Well, we have consultative and deliberative is an out that's used all the time. It's used by the executive branch at the state for refusal to release documents. We worked on a definition of consultative and deliberative, which we hoped will tighten it up. I'm not a lawyer, so I didn't get too involved personally in that issue because I didn't understand it well enough to be able to get directly involved, but I know it's been used as an out, and we did try to tighten up that definition in the legislation.
Just if I could comment, I think that under even the existing law, what they're doing is illegal. That if what they're doing is doing their policy formulation via email, they can't do that. They're supposed to do things regardless of whether they're able to redact this from the emails. And I got a comment about that as well. They're not supposed to be doing their deliberative aspect. They're not supposed to deliberate these things outside of the public view. So it seems to me that if a pattern of this misconduct, I'm not sure what a pattern is. I learned from Judge Curio in Cumberland County that 3 instances of the identical violation was not a sufficient pattern to warrant my lawsuit, but maybe 4 is. I'm not sure. You'd have to find, maybe 10. Okay, whatever. But when if you get a pattern of this and show it in the emails and the redacted emails, that should be, you could win an injunction against them to prevent them from doing that under the current law or under the revised law. The second thing is I think that the argument that they're making that the email discussions are consultative and deliberative and therefore exempt from access and redacting is rather dull. Because if they were abiding by the law, those very same conversations that they're having via email will be done in the live testimony in front of the audiences, the public. In other words, the entire purpose of the Open Public Meetings Law is to make them deliberate these things in public. And if they choose to use, illegally in my view, a means of achieving the same end through depriving the public by email, it just seems rather stupid, frankly, for them to even suggest that those emails themselves should be confidential as deliberative, because the purpose of the legislation is to make the deliberations public. So I mean, that's so wrong on so many levels that, but I think you just have to, when you get the attorney fee shifting provision and you can afford to do so, see if you can get an attorney to take a look at that and get injunction against them and make them stop. That's what I think needs to be done.
Yes, sir.
Are there any other bills attached to these bills that would sink these bills overall on a vote? Or are they being presented, each bill being voted on in itself by the governing bodies?
Yeah, these aren't like federal bills where they can attach some sort of a rider onto it. The state constitution requires that each bill address essentially one topic. So no, these bills are just OPRA, OPMA with no like, you know.
We're not allowed to do that in the state. We can't put extraneous things into a potential piece of legislation. Only the governor can do that.
Yes, ma'am.
Can you talk a little bit about towns being able to limit how you can submit an OPRA request? I tried to submit to Newark and I had to fax it in.
Now, I believe in the bill, correct me if I'm wrong, John, you're probably more of an authority than I am. You can submit an OPRA request any way you choose, and they must take it. It could be on a paper napkin, whatever.
Well, that's my fault.
No,
I apologize. we made a tactical error in Walter is part of that too. That we made a tactical error in appealing the GRC's opinion that the language in OPRA that says that you can send it in by mail, you can send it in electronically, you can send it in, that meant that we got the choice of like how we submit the OPRA request. And the GRC in some tortured language came up with like, well, that doesn't mean that. It means that the town can select from among those options and restrict you from using certain electronic mechanisms. That's one thing, so that's resolved. The second thing is some towns I've really buried deep or don't put into their websites the actual contact information for the municipal custodian. I mean, I've seen this, you look at it, and they'll have like a picture of the clerk, the duties of the clerk, the fact that we run the elections, we do this, we do that. Who is the clerk? We're not telling you. Who I've found myself, I will like go clerk at, Wantage Township, just as an example, not them. And I will do various iterations of OPRA at, clerk at, and put it through the Google search engine to see if I can actually, I'll take the last name of the clerk and I'll put that in with the first initial to see if I can actually derive from some other document on the internet what the clerk's email address is. That's ludicrous, but that's what they do. And this bill will say that they actually have to provide that information on their website if they have one.
Well, I'm laughing because Jennifer Borg, who's the vice president of the record, as I said, was a partner in this. At one of the committee meetings where she was giving testimony in one of the budget or state government, she held up a list she got from the state of government record custodians that have been redacted. That is the honest to goodness truth. When you go back to the record, Mr. Snowflake, you ask her to see that. It's a list with all these telephone numbers or emails, whatever, all blacked out. The government record custodians for each department of state government. I mean, again, it was like everybody laughed, but that's the way she was given the information.
Okay, we're almost at the end of this segment, so Ian, with my usual caution.
John brought up a very interesting thing about the record custodian. Although the statute, as it now exists, is silent on deputy custodians, yet I believe it's in the GRC handbook that permits the custodian to appoint deputies in various departments. Council has nothing to do with it. I think it might behoove you, and I hate to throw a wrench into this if you're that close to getting it done, but to add something in there that will permit the custodian to appoint deputies and have it posted on, because as a good example, my police station was across the street. Rather than somebody coming in to me to make a records request for an accident report, I appointed the head of the police records division as the deputy with minimum amount of responsibility. And the health officer was the deputy to give birth certificates and marriage licenses, because the state health department had certain restrictions. And I think you might want to look at that to tweak it a little bit more and post those names as well, because I know a lot of towns have a slew of them out there.
Yeah, well, that's a good suggestion. We will take a look at it. I don't know if we address that or not.
Well, we're almost out of time, so Senator, I wanted to give you the opportunity if you wanted to make any final comment on the issue of these upcoming amendments.
No, hopefully, as I said, you're going to see them passed and ready for signature by the end of the year. And you've got to keep your grassroots advocacy up and alive. We can't do it without people like you. And we certainly, there is no sense doing it unless we have an educated public who are educated enough to use the tools that we're giving them to find out what their governments are doing. And, you know, I don't mean to sound like I'm in some different class of citizen. When I have trouble getting information from my own town, you know, I mean, you can laugh. I can say, well, and I'm a pretty savvy consumer in this area. It's not easy for the general public out there. And I'll close with what I opened with. Good government is open government. So.
John, any final thoughts?
No.
Senator, thank you very much. Another round of applause for our panelists.
Thank you.